कोल्हापूर जिल्हा बार असोसिएशनतर्फे सर्वांचं सहर्ष स्वागत. आपण सगळे आनंदोत्सव साजरा करत आहे. कालचं आलेलं नोटिफिकेशन त्याच्या अनुषंगानं, त्यामुळे आता आपण अधिकृतरित्या माननीय नामदार मुंबई उच्च न्यायालयाचं सर्किट बेंच कोल्हापूर असं उच्चारू शकतो. तर आज आपण डिव्हिजन बेंच, आज आपण कोल्हापूर जिल्हा बार असोसिएशनतर्फे माननीय नामदार मुंबई उच्च न्यायालय येथील ज्येष्ठ विधिज्ञ अशोक पी मुंडरगी साहेबांचं व्याख्यान आयोजित केलेलं आहे. त्याचा विषय आहे क्रिमिनल प्रॅक्टिस अँड प्रोसिजर इन हायकोर्ट. या विषयावर आपण व्याख्यान आयोजित केलेलं आहे. ज्येष्ठ विधिज्ञ अशोक मुंडरगी साहेबांचा परिचय द्यायला ते सगळ्यांना परिचित आहेत, कोल्हापूरचे सुपुत्र आहेत. त्यांचं एज्युकेशन कोल्हापूरमध्ये झालेलं आहे. प्रायमरी लॉ कॉलेज लॉला त्यांनी गव्हर्मेंट लॉ कॉलेज मुंबई येथे केलेलं आहे. त्याप्रमाणे एक वर्षभर अशोक मुंडरगी साहेबांनी कोल्हापूर न्यायालयात वकिली केलेले आहे. जे बारदेसकर साहेबांकडं मुंडरगी नावाचा दबदबा बऱ्याच वर्षापासून आपण न्यायालयीन कामामध्ये ऐकतो. जिल्हा न्यायालय असू दे, तालुका न्यायालय असू दे, मान्य नामदार उच्च न्यायालय असू दे, तसेच बेळगाव येथे कर्नाटक येथे जिल्हा न्यायालयातसुद्धा साहेबांचे काका तिथं प्रॅक्टिस करतात. तसेच ह्यांचे लहान बंधू कैलासवासी नाना मुंडरगी हे आपल्या इथं क्रिमिनल साईडला प्रॅक्टिस करत होते. तसेच साहेबांच्या बहीण त्यासुद्धा ताई मुंडरगी इथं आपलं दिवाणी न्यायालयात काम करत होते. आम्हालासुद्धा त्यांच्यासोबत काम करण्याचा योग आला. दादा क्रिमिनल साईडला काशीद मामा असू देत किंवा अजय कुलकर्णी साहेब असू दे, त्यांच्या मार्गदर्शनाप्रमाणे काही कामात आम्हाला त्यांच्यासोबत काम करण्याचा योग आला. ताईंसोबतसुद्धा दिवाणी न्यायालयात आम्ही एकत्र काम केलेलं आहे. आणि आता योग असा आलेला आहे की आपल्यासोबत सर्किट बेंचमध्ये सुद्धा काम करण्याचा माझ्यासोबत कोल्हापूर जिल्हा न्यायालयातील सर्व सन्मान्य सदस्यांना योग आलेला आहे. कोल्हापूर जिल्हा बार असोसिएशनचे अध्यक्ष विहार पाटील साहेबांना विनंती करतो की त्यांनी अशोक मुंडरगी साहेबांचं स्वागत करावं. ॲडव्होकेट अशोक मुंडरगींचे वडील पी आर मुंडरगी साहेब हे नामांकित कोल्हापुरातले वकील असून मी स्वतः त्यांना एकाच दिवशी 3 सेशन कोर्टात, कॉन्टेस्टेड सेशन कोर्टात क्रॉस घेताना मी स्वतः बघितलेलं आहे. अतिशय चांगला आणि असा उत्कृष्ट असं त्यांची क्रॉसची ख्याती होती. त्यांनी बरेच वकील ज्युनियर आपल्या इथं तयार केलेले आहेत. अतिशय म्हणजे माइलस्टोन आहे तो की अतिशय चांगले आपल्यात होते. तसेच नाना मुंडरगीसुद्धा कैलासवासी, ते सुद्धा अतिशय क्रिमिनल साईडला चांगल्या पद्धतीनं वकिली व्यवसाय करत होते. आता त्यांची 3री जनरेशन, त्यांचा मुलगा अनिरुद्ध हा सुद्धा आमच्यासोबत आता जिल्हा न्यायालयात काम करत आहे. तो ह्या वर्षीच लॉ ग्रॅज्युएट झालेला आहे. अशा परिस्थितीत मुंडरगी साहेबांचं योगदान कोल्हापूर जिल्हा बार असोसिएशनसाठी, तसेच आपण जो केंद्रबिंदू मानतोय पक्षकार, तो केंद्रबिंदू ठेवून त्यांनी बऱ्याच पक्षकारांना न्याय दिलेला आहे. अशा मुंडरगी फॅमिलीचं कोल्हापूर जिल्हा बार असोसिएशनतर्फे स्वागत व खूप खूप आभार. आता मी ज्येष्ठ विधिज्ञ अशोक पी मुंडरगी साहेबांना विनंती करतो की त्यांनी आपलं व्याख्यान सुरू करावं.
सगळ्यात पहिल्यांदा तुम्हा सगळ्यांचे पहिल्यांदा अभिनंदनाला पात्र असलेला हा वकील वर्ग इथं जो हजर आहे, वकील आणि वकील वर्ग आज सच तुम्ही सगळ्या या हायकोर्टच्या मागणीसाठी, हायकोर्टच्या एकंदर जी आंदोलनं झाली, मागण्या झाल्या, या गेल्या जवळजवळ अनेक वर्ष तुम्ही त्याच्यात अग्रेसर होतात, तुम्ही ते लीड केलेलं आहे. बाकीचे जे लोक त्याच्यासाठी जबाबदार होते, ज्यांनी त्याच्यामध्ये त्यांचाही कार्यभाग होता, त्यांचाही हातभार लागलेला आहे, परंतु सगळ्यात या आंदोलनामध्ये वकील वर्ग हा अग्रेसर होता. हा तुमच्या अभिनंदनाचा विषय आहे आणि पहिल्यांदा माझ्या भाषणाची सुरुवात पहिल्यांदा तुमचं अभिनंदन करून मग मी, हे तुमच्याशिवाय झालं नसतं. बाकीची सगळी आंदोलनं होतात ही अनऑर्गनाइज्ड होतात. कुणी तर मागणी करतंय, कुणी तर नाही म्हणतंय, कुणी तर होय म्हणतंय, परंतु एक हे ऑर्गनाइज, ह्याला एक दिशा जी मिळाली ती फक्त तुम्ही देऊ शकत होतात आणि ती तुम्ही दिलेली आहे. एक दोन गोष्टी विषयाला वळण्याच्या अगोदर मला तुम्हाला प्रकर्षाने सांगायला लागतात, सांगाव्या अशा वाटतात. इथं मी बघतोय बरीच ज्युनियर मंडळी आहेत, खूपशी ज्युनियर मंडळी आज मला इथं दिसत आहेत. आणि त्यामुळे हा माझा सल्ला हा सिनियर लोकांच्यासाठी नाही आहे. सिनियर लोकांनी कान मिटून घेतले तरी हरकत नाही. मी ज्यावेळेला मुंबईला गेलो आणि मी विषय हा करणार आहे, विषय मी जरूर तुम्हाला सांगेन. मी माझं मला जो सब्जेक्ट दिलाय साहेबांनी तो मी नक्की हे करेन. तर त्याच्या अगोदर थोडं बहुत मला बोललं पाहिजे. मी ज्यावेळेला मुंबईला गेलो 1973ला मी मुंबईला गेलो. मी इथं राजाराम कॉलेजचा विद्यार्थी होतो. इकॉनॉमिक्स आम्ही मराठीमधून पेपर लिहिले होते. मराठीमधून पेपर लिहिल्यानंतर मुंबईला ज्यावेळेला आम्ही गेलो, माझ्याबरोबर 1-2 वर्षानंतर खोतलांडे वगैरे सगळी मंडळी आली. तिथं जो आम्हाला त्रास झाला वर्गामध्ये, आम्ही जवळजवळ 6 महिने पहिले आम्ही तोंड सुद्धा उघडू शकत नव्हतो की कर्ता कर्म आणि क्रियापद कसं काय लावायचं आणि काय एक वाक्य करायचं आम्हाला येत नव्हतं. आजची परिस्थिती अशी आहे की हायकोर्टाची ऑफिशियल लँग्वेज इंग्लिश आहे. आपण इथं सगळेजण, आणि अगेन हे मला ज्युनियर लोकांच्यासाठी हे सांगणं आहे, इंग्लिशवरती प्रभुत्व हे तुम्हाला हायकोर्टमध्ये ज्यावेळेला तुम्ही प्रॅक्टिस करणार किंवा हायकोर्टमध्ये तुम्हाला प्रॅक्टिस करायची ज्यावेळेला तुम्ही डिसिजन ज्यावेळेला घ्याल, त्यावेळेला इंग्रजीवरचं नुसतं वर्किंग नॉलेज नाही, तुम्हाला टॉपला जायचं असेल तर तुम्हाला त्या लँग्वेजवरती, त्या भाषेवरती प्रभुत्व असणं गरज आहे. हे आजपर्यंत आपण बघत आलेलो आहे. मी इवन औरंगाबादला ज्यावेळेला मी जात होतो, मी जायला सुरू केली त्यावेळेसही सुद्धा मी हे बघितलेलं आहे की ज्यावेळेला नवीन बार होतोय, नवीन हायकोर्ट होतोय, तर त्यावेळेला बऱ्याच गोष्टी ह्या त्या बारला माहिती नसतात, वकिलांना माहिती नसतात, किंवा वकिलांची ती तेवढी तयारी नसती की एकदम अचानक हे ट्रान्झिशन आहे ट्रायल कोर्टामधून हे डायरेक्ट हायकोर्टामध्ये किंवा डायरेक्ट अपील कोर्टात किंवा कॉन्स्टिट्युशनल कोर्टात, हे ट्रान्झिशन जे आहे, तर ह्या वेळेला बऱ्याच वेळेला काही अडचणी येऊ शकतात. ज्युनियर मंडळींनी हे प्रकर्षानं ध्यानात ठेवावं की तुम्हाला ह्याच्यामध्ये ह्या 2-3 गोष्टी तुम्हाला सांभाळाव्या लागतील. एक म्हणजे लँग्वेज, दुसरी म्हणजे प्रोसिजर, आणि तिसरं म्हणजे इथं क्रॉस एक्झामिनेशन नाही आहे, इथं नवीन एव्हिडन्स नाही आहे, इथं कुठल्याही परिस्थितीमध्ये तुम्ही वेगवेगळे कागद मी हे करतो, पुर्सीस देतो, हा कागद घालतो, तो कागद घालतो, अशातला हा भाग येत नाही इथं. त्यामुळं ज्या काही कागद खालच्या ह्याच्यामधून तुम्हाला संपूर्ण रीडिंग करून वाचून त्याच्यामधल्या काय त्रुटी असतील, त्याच्यामध्ये तुमच्या बाजूचं काय असेल, तुमच्या विरुद्ध काय असेल, हे तुम्हाला हुडकून काढून ते तुम्हाला प्रकर्षानं आणि इफेक्टिव्हली तुम्हाला हे कोर्टापुढे मांडता आलं पाहिजे. हे ज्युनियरसाठी होतं, सिनियर लोक यातून पोहून गेलेले आहेत, तुमच्यासाठी नव्हतं. आता ह्यातल्या 2 गोष्टी आहेत की हायकोर्टामधून, लेट मी नाव गो टू माय सब्जेक्ट्स. When you are transiting from trial court to the high court, there are many things which you must consider as new. Now, I'm not talking about, or I'm not even speaking, and I'm not even suggesting that the lawyers here do not know the revisional jurisdiction. They do not know the bail jurisdiction. They do not know, no, they know everything. Because you have argued bail matters, you have argued revisions, you have argued even appeals. Nothing is new to you. And therefore I am restricting today's speech, or rather today's dialogue with you. It is not a speech. Speech means it is boring. A dialogue is only in respect of what is new in your jurisdiction when you are entering the High Court. The applications for bail, the revision applications, the scope of 397, 401 and so on and so forth remains the same. There is nothing new. You have to only adjust yourself to new kind of approach by the judges. But what is new is the first in appellate side, appellate jurisdiction, is the death confirmation matters. As you are all aware, basically the sessions trial ends in conviction, acquittal, whatever decision is given. And sometimes, in a rarest of a rare case, there is a death sentence awarded. And in Kolhapur also, I think you had appeared in one of those cases. The death sentence is awarded. Now, this death sentence is compulsorily submitted. The entire proceedings are submitted before the High Court for confirmation of the sentence. In that confirmation, that is old 366 to 371, there are a lot of confusion, 465 to 469 under the new law. But that apart, the jurisdiction remains the same. It is ad verbatim same procedure. There is no difference in the procedure. Now, in these proceedings, I must take you in confidence that a death sentence has compulsory. It is a compulsory thing that the High Court must look into everything, including the evidence, including the submissions, including everything, before the death sentence is confirmed. Now, sometimes there is a requirement, or rather a desire, that the accused and the accused lawyer feels that even we should file an appeal. Such an appeal is not needed. Such an appeal is not needed. The only advantage of filing such an appeal in death sentence matters by the accused is that they get the first right to open the matter. Because it is an appeal against the entire conviction, which will include the sentence as well as the conviction. So that is the only difference which you will feel and you will get in these confirmation matters when the confirmation matters come before the High Court. Now, rest of the jurisdiction is the same. Now, what is new in respect of the High Court and the High Court jurisdiction? The first thing which you will come across is the inherent powers. The inherent powers are never with the trial courts. The trial courts do not possess the inherent powers. It is said that the trial courts, including the court of the magistrate and the court of the sessions, are the creatures of statute. They are created by the statute, conferred powers by the statute, maybe criminal procedure code, maybe some other statute, but they confer the power on a, say, magistrate or say a special judge or any trial court by a particular statute, particular legislation. Now, if you must have noticed the language of section 482 contained in the criminal procedure code. It says that saving of the inherent powers. It is only High Court under 482 and the Supreme Court under Article 142 and even maybe 32 of the Constitution. they possess these inherent powers. The inherent powers are to be exercised, but I will give you the illustrations later on. But these inherent powers are basically the saving of the powers by the High Court or by the Supreme Court. We are concerned with the High Court, so we will deal with the High Court only. To do complete justice between the parties. I will give you one or two illustrations. One illustration. Now there is a case where a process is issued. Now you are all aware, we deal with these cases. You people have come to us filing the matters for quashing in the High Court. Now a process is issued and a process is challenged either in the revision application before the Sessions Court or by filing a 482 petition in the High Court. Now at the time of the commission of the offence which is alleged in that particular thing is so watertight that the magistrate had no other option but to issue process, and he could not have done otherwise. Now the accused says that when the offence, this particular thing was committed or alleged, I was not even in India. He produces his passport or visa or whatever, a ticket. Or say I was in Delhi, I was in so many other places, and I could not have been present in the place where the offence was committed. The Sessions Court, where you are filing a revision, would naturally and normally will say that I don't have the power to look into these documents, even though they may be impeccable value. I can't look into this for the simple reason that I am here to see whether the process was properly issued or not, whether there was material before the court or not. Now in such a circumstances, the inherent powers come to the rescue of this is to do complete justice between the parties. Now, this is complete justice between the parties and secure ends of justice. Now, there are two jurisdictions so far as 482 is concerned. One is exercisable by the single judge. One exercisable by the division bench. You must have come across many such situations that you are coming for quashing, but one matter goes before the single judge and one matter goes before the division bench. Now these division bench and single judge bifurcation is on the basis of the rules of the High Court. These are called High Court Appellate Side rules. Now under the High Court Appellate Side rules, there is a chapter business of the single judge before the single judge, business before the division bench. Now whatever is specifically provided to be dealt with by the single judge goes to the single judge, and all residuary matters, everything which remains goes before the division bench. Therefore, these two jurisdictions, though similar, identical, and can be exercised by the High Court in the given circumstances, are only circumscribed by the High Court Appellate Side rules. I am dealing only in the criminal matters. Now, 482 is basically meant for quashing, meant for correcting the orders, and several such jurisdictions which you will come across and you will deal with when you ultimately start dealing in these single judge matters and the division bench matters. Now, the trial courts, why the trial court do not have these powers? There is a specific reason for not giving such a powers to the trial court. Firstly, because the High Court as well as the Supreme Court are constitutional entities. They are the creatures of the Constitution. One, they have got supervisory jurisdiction over the entire state. The High Court will have the supervisory jurisdiction over the entire state. The Supreme Court will have the same jurisdiction over the entire country. Now, trial courts, if these inherent powers to do complete justice between the parties and it's called to secure the ends of justice, if it is given to the trial courts, it being ultimately manned by a human being, everybody's conception or everybody's idea of what is complete justice and what is securing ends of justice can differ. One. Two, there can be a totally divergent and inconsistent decisions by the same courts at the same level of jurisdiction in different jurisdictions. There may be several such incidents where once judge says that this can be a sufficient ground for quashing an order, or this is not a sufficient ground for quashing the order, if we look at a different or a document or a fact which is not a part of the record. So these inconsistencies, to avoid these inconsistencies and these possibilities, principally they have said that the trial courts, including the sessions court, though it has a power of revision or other powers, appellate powers, are the creatures of the statute, and unless and until a particular power is given to them by the statute, they will not be able to exercise such a jurisdiction. Now, there are also one more possibility, or rather one more reason for this. There has to be uniformity of decisions if the decisions are to be given on a basis of some such a material which you can rely upon, which the other side can rely upon, which is not part of the record. These are of course circumscribed by several judgments, and as you all must be aware, Bhajanlal remains the Bible on all these subjects. They have laid down certain criteria that you fall under this and the decision can be given. But basically, as on today, the High Court and the Supreme Court only will have this jurisdiction of inherent powers. The section also says that, and the circumstances in which it can be utilized are also prescribed. Now, a situation arose somewhere in between that so far as Bhajanlal is concerned, Bhajanlal ruled the scene for quite some time. But then there were certain offenses under the Indian Penal Code, under old 320. I don't know what is the new provision, but under old 320, every time even I take the comparative table when I am arguing, and because I also commit the mistake, and it is impossible for within 6 months to understand what are the equivalent provisions. So I go on the old law. Under the old 320, certain offenses were compoundable and certain offenses were non-compoundable. There were several amendments made, and a chapter was added even in the earlier CRPC of compounding of certain offenses by way of compromise. Now, I am not aware till today that under that newly inserted chapter, how many cases were compounded, because it was wholly unworkable. It required a minimum sentence to be given to the accused. It required the complainant to agree for everything. It required the court also to agree to everything. It required the public prosecutor to say his no objection. Now, with all this, who would go everything to be done by you, and who will still go and serve 1/4 or 1/2, I think 1/4 of the sentence, and go to the jail and serve out that sentence after doing all this. So according to me, that chapter became a redundant chapter in the Criminal Procedure Code. But that apart, now matrimonial offenses were treated at par with the non-compoundable offenses. Initially 498A was not at all compoundable, even it is, now it is, there is some new provision, but then under the old law it was not. Now 498A, 406 and all these are the normal sections which can be invoked or which are usually invoked in the matrimonial disputes. So for first time B.S. Joshi came. The Supreme Court in that judgment of B.S. Joshi said that ultimately it is a matrimonial case. Husband and wife are fighting. What is the use of allowing that fight to go on endlessly till they end their own life or they come to the fag end of their life? If it is to be settled and if the both parties are ready to settle, then it has to be settled as early as possible. Now till then, this particular provision had remained on the statute book as non-compoundable. Some judges used to allow, some judges never used to allow, even in the quashing petition. So 482 at that time was effectively used by the Supreme Court for quashing, though exercising the powers under their jurisdiction. Then it percolated right up to the High Court. Now even in the High Court, nobody even asked the question if it is a matrimonial dispute and if husband and wife are present in the court, then it is put an end to within no time. These are some of the instances where the inherent powers are utilized. Inherent powers give a widest of the discretion to the High Court. At the same time, it also says that it is to be used in the rarest of the rare cases, in the exceptional cases. All those conditions, preconditions, though attached to it, it remains to be a very vital and widely used power for the High Court under 482. There is also another jurisdiction of the High Court, and that is 483. Very few people have utilized it. Very few people approach the High Court for any grievance under 483. It is a continuous superintendent's power over the magistracy, over the courts of the magistrate by the High Court. Now under this also, whatever your grievances, whether arising of the judicial proceedings, administrative proceedings, they can be brought to the notice of the High Court under this provision in a separate proceeding. It is of course High Court's power. It is not your right. It is not, even 482 is not nobody's right. It is the High Court which will exercise that power if it feels that it is correct. Now this is so far as the quashing, or rather the provisions of section 482 and 483 of the Criminal Procedure Code are there. Then comes a very wide jurisdiction of writs. I am aware, because I was told by your Mr. Patil, your Honorable President and others, that two distinguished guests have already spoken about writs. The third, not so distinguished guest speaking only on the writs would bore you and many people will leave the hall. So I can't do that injustice to you, and therefore I am restricting these writs only so far as they relate to the criminal jurisdiction and nothing else. I will not enter the controversy, or rather the subject of drafting. I will not enter the subject of the jurisdiction under 226 of the Constitution of India. I will only deal with these few writs which can be, which you will be able to argue so far as the criminal matters are concerned. So far as the civil matters are concerned, I stopped civil practice in 1997. Thereafter, I have not read a single judgment on the civil side. So therefore, please don't ask me any question even at the end. So far as the civil matters are concerned, I will not be able to deal with it in any manner whatsoever. Now, writs, as you are all aware, to enforce the fundamental rights, to enforce or direct the enforcing of directive principles, and so many other jurisdictions are falling under the writs. Now 226 writs basically lie against, of course there are exceptions, I will come to the exceptions also. They essentially are to be directed against the authority, except in some cases like habeas corpus etc., they can be directed against the individuals as well. But as a thumb rule, as a general rule, the writs under 226 have to be directed against the authority as defined or as described under Article 12 of the Constitution. Now, so far as the criminal matters are concerned, you are all aware that there are detention matters under COFEPOSA, detention matters under MPIDA, detention matters under the NDPS Act. There are so many other jurisdictions. Now, there are also detention matters where people complain about the illegal detention by the police authorities or by the authorities like customs, like so many other authorities which have a detaining power, which have arresting power, as the in breach of section 57 of the Criminal Procedure Code, as well as under Article 22(2) of the Constitution, which provide for no person will be detained in custody beyond 24 hours without the permission, without the sanction, without the order of the concerned magistrate or concerned authority. These petitions are also forming part of the habeas corpus petitions which can be filed in the court under different heads. This is so far as the detention matters are concerned. Now, detention matters are basically to protect the personal liberty. Then as I said that for wrongful confinement, wrongful arrest. Also, detention of minors in the protective shelters and those remand homes and other institutions. If such a minor is detained there without any authority or without any reason. There are cases which you will come across which can directly be filed in the High Court, where people are wrongly branded as mental cases and detained in the mental asylums or mental hospitals. These are also forming part of the habeas corpus petitions which can be filed. There are other instances which you are all aware of, a minor girl running away with her friend, elopement, then the father filing it, or the minor girl or even the major person detained against his or her wish by the adversaries. All these petitions can be filed for habeas corpus, and only in the habeas corpus this direction, produce the person, produce the body, produce the person, can be filed against even an individual, a private individual, not necessarily the authority as provided. So a private person also can be subjected to a direction from the High Court that there is an allegation that you have detained this particular girl in your house, you produce her before the court. And such a writ would lie even though it is against a private individual. Now, these petitions again have very wide jurisdiction given to the High Court. This can be filed, these petitions can be filed by anybody. Anybody means anybody, you need not be a relative, it can be filed by a relative, it can be filed by the next friend, it can be filed by even the strangers. As even the social activist, Sheila Barse's case is famous on this, that a third party just coming before the court and saying that, well, this is an injustice being caused to a particular class of people and therefore you interfere. So These are the writ petitions for habeas corpus which can be filed by anybody at any point of time, and there is no limit as to who should approach, and there is also no limit on the court as to how it should be exercised. It can be exercised against anybody. Then the second category of writs is mandamus. Now, so far as criminal matters are concerned, you will come across the writs in a very specific jacket, or rather specific parts. The major litigation under 226 in the High Court will be when person comes before the court and says that this FIR filed against me is wrong, it should be quashed. The other group of petitions are that the police are not taking action, they are not recording my FIR, so therefore direct them to record my FIR. And the third category, these are flowing from the same mechanism, same procedure, that police are either acting excessively, police are not acting in any way whatsoever. The third category, that though my FIR is registered, though there is an FIR which is at my instance, the police are not taking any action, and therefore you transfer the investigation. And the last of this in Mandamus is that there are so many cases filed against a person, like in this MPIDA and other provisions, that you club all these cases together so that I can face one case and finish the whole thing, because they all arise out of the same transaction. The 226 petitions, so far as the High Court is concerned, in Mandamus would be only of this nature. 90% of the litigation is this: 1, you record it; 1, why you recorded it; 3, transfer it; and 3rd, club it. It's very, very simple straight jacket formula which I have done for you. There are 90% of the litigation under 226, apart from habeas corpus, is of this nature. Now, I will not bother again giving you the judgments on this issue, because nowadays it is so simple that you don't have to go to the library, you don't have to go do anything. You just go to ChatGPT and push the button and you get the judgment. My juniors, when I ask एका ह्याच्यावरती मला एक जजमेंट पाहिजे, मला साधारण 20 ते 25 जजमेंट आणून देतात. मला वाचायला कंटाळा येतोय, आणि ही 20-25 जजमेंट कशी काय वाचायची आणि यातनं काय काढायचं हा प्रश्न पडलेला असतो. Now therefore, I will skip all these judgments. No judgments. Now, there are another category of writ petitions which are in the nature of prohibition. Now, basically, prohibition writs are very rare on the criminal side, because prohibition writs, writ of prohibition, is before the order is passed, and essentially this jurisdiction is more often used on a civil side, on a service side, service litigation side, because under the criminal law, right from the beginning, today now in this new act there is some difference in respect of the rights of the accused before he is made an accused. Today the new procedure code provides for, in a private case, a notice has to be given to the accused. This provision was not there. On the contrary, the entire case law on this subject dealt with how the accused has no right before he is made an accused. The same principle could be imported in the writs of prohibition, that unless and until any order is passed against you, you can't challenge. Only exception was anticipatory bail, which was a statutory provision. Nothing came under the constitutional powers, nothing came under the writ jurisdiction. Now, in exceptional cases, the High Court might have exercised this jurisdiction in the criminal matter as well. Like when there is a person who wants to come back to India to face a criminal trial or a criminal allegation, and he fears that once I step into onto the soil of India, I will be picked up, I will be arrested at the airport and all that. So sometimes in such a situations, the High Court has exercised such a jurisdiction on a prohibition, a writ of prohibition, asking the authorities not to detain, not to stop the person, and on his undertaking that he will come and answer all the charges. But with this exception, and there may be one or two more, the writ of prohibition is not a very popular writ, or the lawyers need to be conversant with this branch of writ of prohibition so far as the criminal law is concerned. There is another writ which is basically a writ of certiorari. Now, certiorari can be on both sides, civil as well as criminal, and the certiorari writs for quashing the orders passed by the passed by the lower courts, by the authorities, by the tribunals, by all the entities which can be covered under Article 12. This is one more exception to the general rule that generally the writs don't lie against the judicial orders which are passed. Writs don't, you can't file a mandamus against because already there is a power vested in the superior court to correct the decisions of the trial court or of the sessions court. And therefore the writs basically are not entertained so far as Article 226 is concerned. Except the fact that the writ of certiorari, when it is used against the orders passed by the judicial orders, the jurisdiction which is exercised is under Article 227 or under 482. Though one is a statutory power and one is a constitutional power, both vest the High Court with the aspect of supervision over the courts below. Article 227 as well as Section 482 are the supervisory powers of the High Court. The High Court can exercise these powers, and therefore a certiorari, a quashing, can be done by the High Court by exercising the powers not under 226 but also under 482 and 227. Now, there are one or two things so far as these writs of prohibition and writs of certiorari are concerned, that there are now several tribunals which are invested with the powers which are also penal in nature. Like even in the criminal, even under the company law, even under several other laws, there are provisions that certain breaches are described as offenses. Now, these offenses falling on the criminal side again are within the jurisdiction of the High Court, though the powers of trial and powers of appeals are exercisable by different authorities as provided under those statutes. So far as the criminal jurisdiction is concerned, as I promised you, I will not audience by revisional and appellate jurisdictions, because both are you are very, very well versed with. But one aspect I must touch and leave it at that. High Court is virtually the last court where the common man can seek justice and has an access to. Supreme Court, even for a rich litigant, is beyond his reach. So therefore, so far as the High Court is concerned, these are the powers which are given to senior judges. The writ jurisdiction is, as you must have seen, always the division bench which is headed by one of the senior judges is invested with the jurisdiction of this nature. Because there is lot of latitude, lot of freedom, though circumscribed and limited by several judgments and those cautions which are sounded by apex court and high courts. But these are the courts which are headed by senior judges. They know the law. They know the law. So when my junior friends will go and start arguing writ petitions before the High Court, it is my earnest request to you that certain judgments which are what we call them the Bibles of that particular topic, you should first read those judgments, take out what is in your favor, and then start drafting such a petitions. You should not draft the petition with your grievance. Your grievance comes later. Your grievance is near to your relief which you are seeking. The law on that particular subject must be molded with your pleading so that your prayer is in conformity with that particular grievance which you are making. We have seen even in the High Court, of course we also in our junior days must have made these mistakes, but today looking back, I feel that the petitions under 226 which come to the High Court, instead of fitting your case or adjusting your facts within those parameters laid down by the various High Court, various rulings of the Supreme Court, High Court, the juniors start giving the grievance first. Why the grievance comes first is because the law governing this particular field is unknown to the. Just the other day, a junior lawyer was arguing that there were 10 accused and he had come for the quashing of the offense for one accused. The court was asking him, the role is similar. How can you ask for quashing of one person? Then he said that this is by consent. Then the court turns up to the complainant's lawyer. What is your take on this? That lawyer says, yes, I have settled with him. Then the court said, you settle with others. He said, no, I will not settle with the others. Then the court said, then I am not with you, dismissed. So these things happen. And this is the reason why you should first, those famous judgments, those leading judgments, and then start drafting the pleading. And this applies not only to the article, writ petition, this applies to everything. Appeals, yes, because a small anecdote, since many people are yawning. When I went to High Court, I was a fresh 1 year experience in the Sessions Court. KD Chowgule additional session judge होते. इकडे रणजित मोरेंचे काका बसत होते जुन्या बिल्डिंग मध्ये आणि मधल्या बिल्डिंग मध्ये देशपांडे म्हणून नागपूरचे डिस्ट्रिक्ट जज होते. हे 3 कोर्ट होती. अँड वी यूज टू आर्ग्यू. बारदेसकर साहेब मला द्यायचे एखादी काहीतरी रिव्हिजन द्यायचे. मला एकदा परांजपे साहेबांनी एक वसुलीचा दावा पण दिला होता आणि ते म्हटले, अरे जाऊन चालवून ये. आता काय चाललं मला निकाल मला माहिती नाही. आणि नंतर मला काही परांजपे साहेब मला कधी बोलले नाही, त्या अर्थी तो बहुतेक विरुद्ध गेला. पण ए स्मॉल अनेक्डोट. पूर्वी मी ज्यावेळेला हायकोर्टात गेलो त्यावेळेला जस्टिस वैद्य होते, GN वैद्य. ए व्हेरी टॉल फिगर इन मॅटर ऑफ नॉलेज, इंटेग्रिटी, कायद्याचं ज्ञान. हे जस्टिस वैद्य हे कारवारचे वगैरे त्या भागातले होते. कानडी अतिशय फ्लुएंट बोलू शकत होते, लिहू शकत होते. संस्कृत चांगलं बोलू शकत होते, लिहू शकत होते. मराठी तर होतच होतं. इंग्लिश अफलातून होतं त्यांचं. एक दिवस माझ्याकडे दुसरे सिनियर होते आणि आमचं नेहमीची आम्ही मॅटर चालवत होतो काहीतरी. ते आले आणि त्यांनी एक अपील मेमो काहीतरी अमेंड करायचं काहीतरी सांगितलं की मला एक अमेंडमेंटची परवानगी द्या. वैद्य साहेबांनी ते उघडलं आणि त्याच्यामध्ये काहीतरी त्यांनी अपिलामध्ये, क्रिमिनल अपिलामध्ये 50-60 काहीतरी ग्राउंड घेतली. ती बरीच होती, आता आठवत नाही मला नक्की किती होती, बरीच ग्राउंड होती त्याच्यात. ते म्हटले, व्हॉट इज दिस मनी? दिस इज वेस्ट ऑफ युअर क्लायंट्स मनी, मोर ओव्हर वेस्ट ऑफ नॅचरल एनर्जी. ते म्हटले की ह्याचे कागद ह्याचे हे कशाला खर्च केलं? अपिलामध्ये एक ग्राउंड इज इनफ दॅट आय हॅव नॉट कमिटेड द ऑफेन्स, कन्व्हिक्शन अँड सेंटेन्स इज रॉंग इन लॉ. ऑफकोर्स आताचे जजेस मागतात, सगळं मागतात, पण आता तो भाग वेगळा. परंतु दीज वेअर द डेज वेन द जजेस यूज टू टेल द ज्युनियर्स की तुम्ही काय केलं पाहिजे. पण आता हे एवढं झालेलं आहे. आय स्टॉप ॲट दिस. आपण असेच एक छोटे छोटे टॉपिक्स कधीतरी आपण घेऊया. मी परत येत राहीन. मी औरंगाबादला जसा येतो तसं मी इथं पण येत जाईन आणि असेच एक छोटे टॉपिक घेऊन आपण हे करूया. आणि हे एस्पेशली आम्ही हायकोर्टात पण अजूनही करतो. इवन टुडे वी आर डुईंग इट इन द हायकोर्ट दॅट वी टेक ए स्मॉल टॉपिक, व्हेरी व्हेरी स्मॉल टॉपिक, की एक अर्धा पाऊण तासाच्या पलीकडे जाऊ नये आणि त्याच्यातले बारकावे, त्याच्यातलं हे असं डिस्कस करायचं. मोठे मोठे वकील येतात, जजेस येतात आमच्याकडे. आम्ही जजेसना पण बोलवतो. बिकॉज ओनली देन यू नो व्हॉट द जजेस एक्सपेक्ट फ्रॉम यू. काय अदरवाईज ते तिथं बसलेले असतात, आपण इकडं बसलेलो असतो. वी डोंट नो, देर इज नो इंटरॅक्शन. जजेसना काय पाहिजे, आपण कायच्या स्वरूपात एखाद्या जजला दिलं पाहिजे. नाउ ऑल दीज इंटरॅक्शन्स मस्ट स्टार्ट वन्स वी स्टार्ट appearing in the High Court. It need not be only one-way traffic. There has to be a two-way traffic. There has to be interaction between the judges and the lawyers. मी एक साहेबांना सांगितलं होतं की आपण एक क्वेश्चन आन्सरचं एक छोटंसं आपण हे करूया. तर त्यांनी मला अजय कुलकर्णींनी मला, त्यांनी नाही पाठवलं, अजय कुलकर्णींनी पाठवलं. आणि अजय कुलकर्णींनी मला एवढे प्रश्न पाठवले की एक वर्षभर जरी अभ्यास केला तरी त्यांचे प्रश्नांची उत्तरं मला नाही देता येणार. तर अभ्यासाचं फार मोठं त्यांनी अभ्यास पाठवलेला आहे. पण प्रोसिजरल ह्याच्यामध्ये मी कायद्याचं परत हे करत नाही की प्रोसिजरल ह्याच्यामध्ये हायकोर्टाची प्रोसिजर, आणि तुम्हाला काही शंका असल्या तर तुम्ही जरूर विचारू शकता. आपण एक 10-15 मिनटं आपण साहेबांच्या परवानगीनं एक 10 ते 15 मिनटं आपण हे घेऊ शकू असं माझा अंदाज आहे. फक्त प्रोसिजरवरती आपण करूया, कारण कायद्याचं हे मग ते विषय अगदी अनएंडिंग होत जातात. ते प्रोसिजरसाठी तुम्हाला पाहिजे असेल तर कुणाला विचारायचं असेल तर जरूर विचारा. मी जेवढं माझ्याकडून होता येईल, टू द बेस्ट ऑफ माय ॲबिलिटी आय विल ट्राय टू आन्सर इट. नसेल तर पाटील साहेबांच्याकडे चहा प्यायला मला जायला पाहिजे. चलो नाही हा नाही, मी सांगेन ना त्यांना काय पाहिजे ते. ही सगळ्यांना सांगतो. प्रश्न कळाला साहेबांचा? साहेबांनी असं विचारलं की एका 302च्या केसमध्ये आरोपीला पकडून आणलेलं होतं, परंतु त्याला ग्राउंड्स ऑफ अरेस्ट दिलेली नसल्यामुळं सेशन्स कोर्टानं त्याला पुढचं हे न करता त्याला सोडून दिलं 302 खालच्या गुन्ह्यात. तर साहेबांचा प्रश्न असा होता की त्याला परत अरेस्ट करता येईल का? नाउ अकॉर्डिंग टू मी, माझ्या माहितीप्रमाणे माझ्या वाचण्यामध्ये असं एकाही जजमेंटमध्ये झालेलं नाही आहे. परंतु एक जजमेंट तुम्हाला मिसेस जस्टिस डेरे सिटिंग विथ सम ज्युनियर जज, सम ऑनरेबल ज्युनियर जज, व्हिडिओकॉनच्या मॅटरमध्ये, व्हिडिओकॉनची जे त्यांचं नाव काय, धूत, वेणुगोपाल धूत किंवा आणखीन एक कुठल्या तर अशाच आहे, कदाचित माझी चूक होत असेल याच्यामध्ये, पण त्या केसमध्ये कोर्टानं हे परमिशन दिलेली आहे. कारण त्याचं सांगतो. एक जजमेंट आहे साहेब, फक्त ते आता मी तुम्हाला नंतर जरा आठवून मी सांगेन एक्झॅक्टली हे जजमेंट आहे का त्या दुसरी बँक कुठली कोटक बँकेमध्ये आहे, हे मला आता कन्फ्यूज आहे. परंतु एक जजमेंटमध्ये ह्या डिव्हिजन बेंचनं हे केलेलं होतं की उद्याला जर का पुन्हा तुम्हाला अरेस्ट करायचं असेल तर बाय कम्प्लाइंग विथ ऑल द प्रोव्हिजन्स ऑफ लॉ यू कॅन. That person is so far not arrested again. Now I will give you the reasons also. The prohibition from double jeopardy comes under the CRPC as well as under the Constitution, saying no person can be tried and convicted for the same offense again and again. Tried and convicted is the only, according to me, is the only prohibition or only circumstance where the police or the authorities are precluded from taking action against such a person. So first is tried and second is convicted. Either or. Samja tried and acquitted, you can't again try him for conviction. Tried and convicted, again you can't try him and acquit him. Of course, go to the appeal, go in the revision, whatever the other remedies available are available. पण हे प्रोहिबिशन फक्त ह्या केसमध्ये लागू होईल, इतर केसेसमध्ये होणार नाही. त्यामुळं परत करता येईल का जजमेंट मला माहिती नाही आहे की ह्या एक्झॅक्टली ह्या इश्यूवरती काय जजमेंट आलेली आहेत की परत त्यांना करता येईल का करता येणार नाही. परंतु ह्या ह्याच्यामध्ये सुद्धा बरीच जजमेंट अशी आता आलेली आहेत. एक बॉम्बेला केस झाली ती माय नेव्ह्यू निरंजन मुंडरगी, ही अपियर्ड इन दॅट. वरीला एक ॲक्सिडेंट झाला होता आणि ॲक्सिडेंटमध्ये एक स्कूटरवरती एक माणूस आणि एक बाई होते आणि त्यांना फरफटत नेलेलं होतं त्या गाडीमधनं. आणि BMW वगैरे अशी कुठली ती हाय एंड गाडी होती आणि ती बाई मेली. ती बाई पडली, नंतर मेली. ती त्या बंपरमध्ये वगैरे अडकलेली होती, गाडी थांबली नाही. सो इट वॉज द आर्ग्युमेंट ऑन द पार्ट ऑफ द अक्यूज अगेन बिफोर जस्टिस डेरे दॅट त्याला हे दिलेच नाहीत, तुम्ही ग्राउंड्स ऑफ अरेस्ट दिली नाहीत. ग्राउंड्स ऑफ अरेस्ट दिली नाहीत तरी हरकत नाही म्हटले की तुम्हाला माहिती होतं की तुम्ही काय केलंय, तुम्ही काय केलं हे तुम्हाला माहिती आहे आणि यू आर अपिअरिंग इन दॅट CCTV, यू आर अपिअरिंग इन द आणि एव्हरी पीपल हॅव आयडेंटिफाईड यू अँड देअरफॉर नो रिक्वायरमेंट ऑफ गिव्हिंग यू ग्राउंड्स ऑफ अरेस्ट इन सच अ मॅटर्स. This matter was carried by them to the Supreme Court. The Supreme Court has recently confirmed it, that no such grounds are necessary. In given cases, it is not needed. चला, खूप वेळ घेतला मी तुमचा. सगळ्यांचा मी अतिशय आभारी आहे. मी इथेही आलो होतो, मी टाउन हॉलमध्ये सुद्धा प्रॅक्टिस केलेली आहे. मी ह्या तुमच्या ह्या बिल्डिंगमध्ये पण दोन मॅटर्समध्ये मी आलो होतो. बरं वाटलं मला येऊन. नवीन बरेच चेहरे मला भेटले. नमस्कार.
खूप खूप धन्यवाद दादा. आपण केलेलं मार्गदर्शन मोलाचं अतिशय चांगल्या नजीकच्या काळात आणून उपयोगी पडेल. आणि आपण कोल्हापूरला येत राहता, महालक्ष्मी बँकेचे आपण संचालक आहे, त्यामुळे आपण ज्यावेळी मिटिंगला याल त्यावेळेला आम्हाला कळवा. आपण नक्कीच एक अर्धा-पाऊण तासाचं आपलं वेगवेगळ्या विषयावर आपण व्याख्यान ठेवूया आणि नक्कीच ते आपल्याला सर्वांना उपयोगी पडेल. नाही, तिथली मिटिंग झालं खास आपल्या व्याख्यानासाठी याल आपण. त्यानंतर मी कोल्हापूर जिल्हा बार सचिव उपाध्यक्ष TS पाडेकर साहेब यांना विनंती करतो आणि आभार प्रदर्शन करावं.
उपस्थित व्यासपीठावरील कोल्हापूर जिल्हा बार असंघाचे पदाधिकारी, उपस्थित सर्व कोल्हापूर जिल्हा बारचे वकील सभासद, कोल्हापूर जिल्हा बारच्या विनंतीवरून अशोक मुंडगे साहेबांनी आमची विनंती मान्य करून अमूल्य वेळ देऊन उच्च न्यायालयात चालणाऱ्या फौजदारी कायद्याचे व त्यांना आलेल्या अनुभवाचा बहुमोल मार्गदर्शन केले, त्याबद्दल मी कोल्हापूर जिल्ह्याच्या वतीने जिल्हा बारच्या वतीने आभार व्यक्त करतो आणि हा कार्यक्रम संपला असे जाहीर करतो.